Hello, everybody. Welcome to part two. This is the timeline of events relating to Ernst & Young's $100 million June 28, 2022 settlement with the Securities and Exchange Commission. My disclaimer and copyright notice. This presentation is for educational purposes only and is based on the administrative order published by the Securities and Exchange Commission on June 28, 2022. Nothing in this presentation constitutes legal and/or accounting advice whatsoever. The statements and opinions shared within this presentation are those of myself, I'm the author, and not my employers or other affiliated organizations, including but not limited to Irvine Valley College, the South Orange County Community College District, and Cal State Fullerton. This presentation is copyright 2022 by Bennett Tchaikovsky. Any distribution without my express written permission is prohibited. Okay, so we're now going to kind of go through and take a look at the administrative proceeding. And we've kind of created a timeline for this so we can kind of see exactly what happened. So before we do that, though, I do want to share with you is how do I find these types of documents? So the SEC website is the best teaching tool in the galaxy for business. So most of the time when I'm on this website, I'm usually going to company filings, and we can look up something like Tesla. And if I go over here, I can see all their filings, right? So all this over here, you can see their annual report, other things among the, basically these are the different types of things I can go through and see. Where we're interested in going today is an enforcement, right? So you're going to see a lot of different things like litigation releases, administrative proceedings, and this is a great place to do basically research on companies you're potentially going to look for. It's very, very important you know who you're doing business with. So right over here where we're going to be is administrative proceedings. And if we come over here, we go down to June 28th, you'll see this one right over here for Ernst & Young LLP. So when we click on this reference, this is going to take us to the actual administrative order, the cease and desist, and then right over here, and this is basically what Ernst & Young agreed to with the Securities and Exchange Commission. So as you're looking at this, one of the things that I've done is I have tried to go through and cross-reference in my PowerPoint. You'll see me put little numbers behind each paragraph. This is where it's coming from. So let's go ahead and take a look at the actual timeline. Okay, so one of the things that we're going to be assuming here is that EY has the ability to offer continuing professional education to their employees. In California, there are some very strict requirements about doing this. It's California Board of Accountancy Regulation, Section 88.1. I'm going to put the reference to that below. But you have to retain records relating to that continuing professional education over a certain period of time. But one of the things over here is that, let's kind of go through the timeline here. So in December of 2014, an internal EY whistleblower identified a flaw in EY's software. Essentially, the software allowed the user to get everything but one question wrong. You got one question correct, and it allowed you to achieve a passing score. Again, this is what I'm reading in the administrative order, and there was an internal investigation that revealed that from 2012 to 2015, over 200 Ernst & Young audit professionals used the flaw to pass continuing professional education exams, right? So again, this goes back to, as a CPA, we have to have 80 hours every year. I do know that a lot of staff and partners, and this is what happened at KPMG, they're too pressed for time. They're working, crazy hours, but it got caught up with them. And again, committing something like this on continuing professional education is not good, especially because most of the CPE that you'll take is going to be open book, or you're attending a seminar. So it's really, I'm not sure if I would call it laziness or if I would just call it pure, just not being very smart. But again, my opinions, but this is what happened, is that they had 200 EY audit professionals use the flaw to pass the continuing professional education exams. So what did EY do? Well, they took a variety of disciplinary actions against the audit professionals who engaged in misconduct. They also added warnings on their internal continuing professional education exams to remind them that they must be taken independently and that a failure to do so would reflect a lack of integrity, violate EY's code of conduct, and that code of conduct, which is the right way to go, requires personnel to report it. But despite the warnings that were issued by EY, certain audit personnel continue to cheat. In 2016, EY learned that the Denver office professionals shared answer keys to CPE, and then the managing partner of the Denver office warned the staff again. And in 2017, 2 employees were caught cheating on the PEF, which is the professional education test, which you need to take to become licensed. So CPE is just continuing to maintain. PEF is what's going to actually get you licensed, right? So, and they define cheating on internal or external tests, assessments, or evaluations can result in disciplinary action, including termination. You must complete them without assistance from others. Assessments will further your professional development. Not completing a test on your own or sharing or soliciting answers from others during an assessment is cheating. So again, they're continuing to go through and remind employees not to do it. And so even though the SEC's Division of Enforcement noted that the problem continued to persist, no additional controls were put in to detect the misconduct. What could they have done? Well, you could probably put in some kind of a scanner on firm email where you're looking at certain things like exams. If the employees were not smart enough, or they were using the employee email or the company email, they could have been going through and scanning emails. That's one thing I think they could have done. And they also could have, if they caught somebody, they could have really tried to get to the root of it. But again, no controls were put into place. They just continue to basically do warnings. Now, this is basically on EY submissions to the SEC Enforcement Division. So in the first part of this video, I kind of talked about how what happened on June 17th, 2019. The SEC issued an order against KPMG for misconduct, including cheating on internal training exams, and fined KPMG more than $50 million. On June 19th, 2019, EY's managing partner sent a message to all US personnel regarding the KPMG matter. And the message warned, sharing answers on internal or external tests or evaluations is highly unethical behavior in violation of our code of conduct and will not be tolerated at EY. The SEC sanction against the other firm, KPMG, serves as an important reminder of our responsibility to serve the public interest and the need to always act with integrity and honesty. On June 19th, the same day that the partners came out, the SEC sent EY a formal request asking whether they had received any ethics or whistleblower complaints regarding testing associated with any EY training program or continuing professional education course. Now, this is also, I think, where EY may have already made a mistake as well, because internal whistleblowers may have not only reported the ethics cheating to human resources at EY, they may have also submitted it to the Securities and Exchange Commission. So again, big problems. So EY, one day after, okay, this is also, SEC sends you a request. They literally said the next day, they provided a narrative that described 5 matters related to cheating or other misconduct on training programs and assessments. One of the matters was the 2017 tip about 2 employees who were caught cheating on the PEF. None of the matters in that submission involved potentially ongoing misconduct by current employees or misconduct that EY did not appear to have appropriately addressed. So EY sends a message to the SEC. The SEC says, okay, I'm responding to you. Here are the 5 matters. This is it, right? And from the SEC's perspective, when they got that response on June 20th, it gave the impression that EY had no issues. But on June 19th, and this is actually, I need to put this date correct, excuse me. So from the SEC's perspective, the June 20th, 2019 response created the impression that they had no current issues with the cheating, either on training programs and assessments or the ethics exams. However, a day before the 20th of June, an employee reported to a manager that a professional in the firm's audit group had emailed the employee the answers to the PEF. The manager informed EYHR, which was relayed to others in HR. So and various EY attorneys received the SEC's June 19, 2019 request. They reviewed the June 20th submission, and on June 21st, the attorneys were apprised of the employee's June 19, 2019 tip about receiving an answer key to the PEF. So this is really where the big problem came in. Had the attorneys when they found out about the cheating, or they found out about the tip, had they called up the SEC and said, hey, do not rely on that response we gave on June 20th. We're going to go through and now revisit it. We got to do more of an investigation, but they did not do it. And the submission on June 20th did not include what happened on June 19th. Right. So despite the managing's warning, the SEC statement was not corrected. So when you make a disclosure, and I said this on the very first part of the video, you have to once you make it, if it's incorrect, you have to continue to update it. For example, if you issue financial statements and there's something materially misleading about it, you have to inform the SEC that these can no longer be relied on, or you are going to get sued, and it's just, there you go. So again, the problem with EY is they didn't continue to update the disclosures. Okay. Now, by the fall of 2019, EY's internal investigation revealed significant misconduct. Right. So now they're finding out more things that are going on. EY audit professionals continue to cheat by using answer keys and sharing answer keys with others. Audit professionals from multiple offices cheated on the PEF. Audit professionals cheated on a variety of CPE courses, including courses on ethics and other topics. So they found out all this stuff, didn't update the SEC. Professionals admitted to during the investigation that they knew that their conduct violated the code of conduct because of work commitments or an inability to pass training exams. They cheated. And 91 audit professionals requested, used, or shared answer keys after the June 19th message about the SEC's action against KPMG. So even though the managing partner at Ernst & Young made this announcement, it's still kind of going through and happening. And violating EY's policies, a significant number of professionals failed to report that their colleagues were sharing the answer keys. And that's, again, you're going to get in trouble because if you know about it and you don't report it, not only if you're just actually going through and doing it, and the employees did not want to get their colleagues in trouble. So EY's general counsel discussed the firm investigation as it was ongoing with EY's executive committee on October 2019. Members of EY understood that the SEC had sanctioned another large audit firm for exam cheating, had asked EY about tips EY had received involving the exam-related misconduct. EY had received a tip about sharing the answer keys to a PEF exam. And you got to also assume, too, if you're getting these tips, they're probably also going to the SEC. And additionally, the cheating involved more than a small number of individuals in a single office, so it's much more widespread, and EY had not disclosed the tip and C to the SEC. So this is the second time the SEC is mentioning it in the administrative order. So following the discussions, EY chose to broaden its investigation, but they still didn't revise their initial letter to the SEC. EY considered informing the Public Company Accounting Oversight Board, or the PCAOB, This is the organization that regulates auditors of publicly traded companies. That's another one you don't want to mess with. However, EY chose not to contact the PCAOB until the extent of the misconduct within the firm was clearer and had a creditable plan to address the problem. And this took 4 months. What they had, and I truly believe this, had they come to the SEC and said, hey, our initial disclosure was not good, and we're trying to figure this out, work with us, they would have said, okay. I honestly, truly believe that. But again, it's easy for me to go through and say that because I get to play Monday morning quarterback. But remember, the SEC will do the same thing. They have the benefit of 50-50 hindsight. They can say, oh, you should have been doing the right thing back here. You didn't do it. It's your fault. So, and again, the SEC did not learn about the issue of EY's misconduct until March 2020, almost 9 months after the June 19, 2019 request, when the PCAOB informed the SEC that the EY disclosed that a significant number of EY's employees had cheated on its training exam. So, and again, another mistake, they informed the PCAOB instead of calling the SEC. And, if you're the PCAOB, they're going to tell the SEC almost immediately. So I don't know that part of it specifically, but that's from reading the administrative order. That's looked like what happened. So the timeline of EY's conduct during the investigation. So EY conducted a robust investigation of the underlying cheating and provided substantial information to the SEC about the misconduct. EY took action to reduce the risk of cheating, including various employment actions, which included termination. However, this is the problem, right? So they did the investigation, but they did not self-police, self-report, remediate, or cooperate with the SEC's investigation. They're essentially saying that when you gave that response on June 20th, you failed to update that response, and that basically means you're not cooperating with the investigation. So, for example, EY did not do a thorough review of the nature, extent, and origins and consequences of the conduct and related behavior. They did not voluntarily disclose information to the SEC staff, or nor our staff did not directly request and otherwise might have uncovered or adopt new and more effective policies and procedures designed to prevent a recurrence of the misconduct. And this, again, is the key. By withholding the information about the misconduct, EY knew that the SEC staff was investigating. Their silence represented a continual misrepresentation to the SEC. So that's the end of the timeline. We're going to talk about the sanctions next. It's exciting, but I'm reading this all to you directly from the administrative order. That's essentially, when I was preparing this, it's like, wow, this thing's kind of writing itself. But it's juicy, it's great, and it's like, look, I'm not jumping on the grave of EY, right? But this thing is absolutely unbelievable, and especially for an auditing firm who's dealt with the Securities and Exchange Commission, and I just can't believe it happened. Frankly, that's again, it's my opinion. So I want to thank you. Appreciate your liking and subscribing to the channel. If you have any questions, please feel free to email me at 1812cpa@gmail.com. I look forward to seeing you on the next video. Have a great rest of your day.